have the courage to put forward in its publication reference to a country like Trinidad and Tobago. There can be significant damages and there can be significant expenses if people get it wrong. And therefore, it is important to observe that Trinidad and Tobago has featured in some of the darkest ways possible in the commentary which was given in the Netflix documentary, published now for the whole world to see, called The Great Hack. That documentary identified the United National Congress under its political management as entering into a very dangerous enterprise of ethnic division for political gain. The content of that particular material centered upon a theory which was put into effect, which says, according to those who published the documentary, that African children in Trinidad and Tobago will not listen to their parents as it comes to voting, but Indian children will. And that is something, ladies and gentlemen, which doesn't only feature in the documentary, but it features on the back of a publication coming from the architects of this type of work. In particular, it comes from the SCL Social publication. That is a confidential document which was revealed to the world by Christopher Wiley when he attended before the UK committee which was looking into the Cambridge Analytica situation. And today I am able to tell you, in the published document entitled Canto Systems, Service Level Agreement, Canto Systems and SCL Elections, 5th of the 2nd, 2014, at the very back of that publication, at the SCL Social Annex, where case studies were published, Mr. Wiley revealed to the world the publication that came from the Cambridge Analytica minds, tied into AIQ and to SCL, and said this of Trinidad and Tobago. In Trinidad, the elections are dominated by the dual ethnicity of the citizens. Consequently, the Indian population don't believe any messaging from the black population and vice versa. SCL embarked on an ambitious campaign of political graffiti that disseminated campaign messages that, whilst ostensibly coming from the youth, were unattributable to any specific party. Both ethnic groups were therefore able to take credit, and a united youth movement was created. That published document resonated with the documentary by Netflix. And I would like to underscore what this country is treating with in grappling with the Cambridge Analytica issue. And then I would like to say now, as Attorney General and as the central authority of Trinidad and Tobago under the Mutual Assistance in Criminal Matters Act, that in discharge of my obligations, I'm required to call for international cooperation now to bring home this evidence. The reference to ethnicity, to data aggregation, to data mining, to Christopher Wiley's testimony that in Trinidad and Tobago there was interception of communication which was unlawful in internet hacking and in micro-targeting, as that has come out effectively from the British House of Commons and also from the United States congressional or senatorial committees. That is actionable in all likelihood in Trinidad and Tobago. And therefore, having participated in meetings with Christopher Wiley myself, together with other persons from other prosecutorial agencies in the world, I am able to say as follows. As Attorney General, I was invited to the National Crime Agency in the United Kingdom and participated together with the National Crime Agency, the District Attorney of New York, with the Elections Commissions and the Information Commission of the United Kingdom, with the FBI coming out of the United States of America, and several other parties in receiving cooperation and testimony coordination for Mr. Christopher Wiley. That was followed up by our UK attorneys meeting with attorneys for Mr. Wiley. Certainly, I also had participation in some of those activities and met with Mr. Wiley in my investigative capacity as Attorney General in securing his commitment to give testimony to Trinidad and Tobago. This testimony was put on pause whilst publications were intended to be produced. We now have the publication, as we see worldwide, of the Great Hack, and in reserve, the Attorney General is entitled under the Mutual Cooperation and Assistance Mechanisms in Law, as central authority, the Attorney General is entitled to call upon law enforcement agencies in other jurisdictions to provide information. That mechanism is now about to be deployed. Further, I will be recommending to the Parliament of Trinidad and Tobago, and in particular the Joint Select Committee that sits on the Cambridge Analytica matter, that Parliament to Parliament, so as to preserve the privileges of Parliament and therefore preserve the immunities and privileges of the UK Parliament and the United States parliamentary context, that our Parliament to Parliament matrix call for and receive the testimony evidence provided by Mr. Wiley to the House of Commons and in the United States of America. This, ladies and gentlemen, is also to be noted in the context that the United States has seen an award of $5 billion United States dollars against Facebook for the participation that it had, whether wittingly or unwittingly, in providing access to over 87 million Facebook users' information. It is remarkable that the rest of the world has taken this issue seriously, and that in Trinidad and Tobago it does not resonate as soundly as it ought to. So by way of information update, in summary, the mutual assistance and cooperation in criminal matters is to be deployed via the Central Authority Office in the Attorney General. And secondly, the recommendation to the Parliamentary Committee to treat with the preservation of privilege and disclosure of privileged material received by the House of Commons and the US parliamentary context is to be recommended by way of AG writing to the Parliamentary Committee. I'd ask you to stay tuned to this matter, because upon the disclosure of that which Mr. Wiley has referred to in his cooperation with the National Crime Agency and with Trinidad and Tobago, there is very likely evidence of criminal wrongdoing and certainly civil wrongdoing. And that is something which must be taken seriously. So I'm pleased to give you that particular update. I turn next quickly to treat with a very pressing matter. I have received hundreds of communications, hundreds of messages from a number of people who are pursuing the entry as attorneys at law via the Legal Profession Act, which permits them to qualify in the United Kingdom and then to effectively undergo a short admission process, either by way of serving an in-service period of 6 months or in the 6-month route that the Hewarding Law School provides. It's the first limb that people are concerned about. As you're well aware, Attorney General Ramesh Lawrence Maharaj many years ago piloted and passed an amendment to the law which permitted this particular form of access. Usually the practice of law, and certainly prior to that amendment, you had to pass through the Sir Hewarding Law School or any one of the other law schools which recognize admission to the bar. There are 3 law schools in the CARICOM context. Of course, there's the Hewarding Law School, there's the Norman Manley Law School, and there's the Eugene Depouche Law School in the Bahamas. Those 3 law schools allow people who have a recognized Bachelor of Laws degree to come through the 2-year course of study to take the professional exam at the bar. A case was brought against the Attorney General and certainly the Council of Legal Education and the Law Association took positions on the matter. This case was brought by one Miss Hadid, and in that there was a complaint that as a CARICOM citizen, she was being unfairly discriminated because CARICOM citizens ought to have the same right as Trinidadian citizens to this alternate form of admission to legal practice. That matter was heard by the Honorable Mr. Justice Bashish Kokaram, and last week he delivered a judgment which effectively struck down the law as being in violation of constitutional rights of CARICOM citizens. The Honorable Judge went on to indicate that as a judge, he was willing to mediate the legislative fix or other fix to this matter. Of course, recognizing the urgency and impact of this decision, the fact that we are aware that approximately over 100 people per year are in this system of admission, and therefore hundreds of locals or persons taking this route will be impacted. People who will have taken loans, people who will have gone to school, people who would have put their lives on pause, not in a legitimate expectation, but in a reasonable expectation of coming through this route, they are all immediately affected. As Attorney General, I have noted as well that the judge's decision is not particularly clear in that it doesn't precisely speak to people who have already qualified via the system. In other words, there is room for addition to the judge's declaration to ensure that people who have been admitted already via this process are not in the position where they're deemed to be without qualification. That would be a conundrum, and that would cause great confusion in Trinidad and Tobago. As a result of the complications of this decision, I instructed the Attorney General's team, led by Mr. Fayed Hussain, Senior Counsel, to immediately approach the court and to ask for an urgent hearing of the matter, to ask the judge to consider suspending his declaration. That matter was heard yesterday, and the judge has reserved his decision until tomorrow. It is very likely that that decision may be the subject of a successful appeal. And I say so because the decision is in need, at least from the Attorney General's perspective, of certain clarity. The Law Association has asked for a 2-year suspension of the matter. In other words, then only 2 years to allow people to come through the system. The Attorney General's position, the government's position, is that we have asked for a suspension of the order until the determination of the appeal. And I'd like to explain why we have taken that approach. We have done that because the issue of providing similar treatment to all CARICOM individuals to Trinidad and Tobago, that is in test right now. There are contingent rights, there are certain privileges under the free movement and skill set in CARICOM, and therefore accepting this decision has multiple complications that must be factored. It must also be borne in mind that other Commonwealth Caribbean islands, including St. Lucia, have similar nationalistic exclusions as Trinidad and Tobago has. So there is a lack of conformity if Trinidad and Tobago's judgment by Mr. Kokaram stands while St. Lucia has a different law or St. Vincent has a different law or whatever the case may be. For all of those reasons, we consider it appropriate that the highest court has an opportunity to pronounce on this decision, and therefore we have asked the Honorable Judge to consider a suspension of his order, not making it apply until the hearing and determination of the appeals in this matter. We have been invited, and many people have asked whether the government will approach the Parliament to treat with this issue. My advice to the Cabinet will be, if that call is made in any more graver form, that it is imperative that the court settles this matter first. So we will abide the outcome of tomorrow's decision by the judge. If the judge is minded to suspend his declaration, then the matter can be dealt with only to consider whether it is for a limited period of time or, as the AG desires, until the hearing of the appeal is complete. If the judge does not agree with that position, then we intend to immediately appeal the Honorable Judge's decision, because this is a matter of serious concern for hundreds of people in Trinidad and Tobago who are very anxious about their condition as attorneys who have either been admitted already or those who are at the cusp of admission or in the course of working their way out. I'd like to turn now to the bail bill. And I'd like to center stage some of the positions which are coming up in relation to this bail bill. Ladies and gentlemen, the government has taken to the Senate amendments to the bail law. And in the Senate, we received the support of everybody except 6 people. There were no no's. There were only no's from 6 people. That is the UNC bench. I'd like to put this out in a very clear fashion as to what these amendments are and what they mean in the battle that we are about to engage in, not only parliamentary-wise, but from a state prosecution and anti-crime drive. Ladies and gentlemen, the Bail Act, of course, you will recall, came about by way of a consolidation of the law into its first form in 1994. That law was amended on many occasions, and effectively, in the period 2005 right up until 2015, Trinidad and Tobago had, at least for 14 years, the provision of no bail in 2 circumstances. Number 1, there was the guaranteed no bail provision for the first bit of scheduled offenses. That is where we use saved law. No bail under any circumstances for murder, treason, piracy or hijacking, or any offense for which the death penalty is the law. That has been the law since prior to the passage of our Republican Constitution. That was saved law. The second aspect of no bail, up until 2016, when the law of bail collapsed, the amended law of bail collapsed, up until 2016, the second way in which you could have been denied bail was for a category of offenses in relation to, for instance, anti-kidnapping, anti-gang measures, certain offenses against children, etc. Those amendments stood on the books of Trinidad and Tobago right up until 2016. And very importantly, in the anti-gang context, the amendments for no bail were allowed to come into the law for anti-gang protection in 2011, and the agreement of the Parliament, the unanimous agreement of the then UNC government and the PNM opposition, was that there should be a 5-year period for the operation of that law. So from 2011 to 2016, there was a full 5-year period for no bail for gang matters. I want to remind you that this law was effectively unchallenged. Not a soul in Trinidad and Tobago, not the UNC, not the Law Association, no one brought direct challenge to the court being told that the Parliament has said there shall be no bail for 120 days, and if your trial starts, it goes to 1 year, and if your trial has not been completed after 1 year, you can apply for bail. Not a member of the UNC went to court to challenge that law, and not a person in the Law Association or anywhere else in this country challenged that law directly. There were certain other challenges in the St. Omer case, etc., where the possession of a firearm in certain circumstances was challenged. But that's not a frontal attack on the constitutionality of the law. When Trinidad and Tobago was grappling with the scourge of kidnapping for ransom, then PNM government came to the Parliament and said, let us apply no bail provisions for kidnapping for ransom. Back then, the figure was 60 days. The UNC came and on every occasion sought to put very short sunset periods, 6 months, 1 year. They constantly danced the period. That changed when they became government. When they were government, when they applied for 120 days no bail, they asked for 5 years and they got 5 years. That kidnapping for ransom issue was a very serious issue in Trinidad and Tobago. And for those of you who are old enough in this room, or who are well researched enough and young enough, will know people were scared in this country. People panicked over kidnapping for ransom. The then PNM government was able to tackle that problem and to bring it down to zero because it deployed two resources. Number one, the Special Anti-Crime Unit of Trinidad and Tobago, which was a direct, hard-targeted response team. And secondly, it utilized the no bail provisions of the amendments to the Bail Act. That law was replicated for the anti-gang law. For the anti-gang law to be successful, it was recognized by both the UNC government and the PNM opposition that you could not make sense of anti-gang law unless you had bail restrictions similar to anti-kidnapping laws. The Commissioner of Police approached the government after the reintroduction of the anti-gang law and just after the close of Parliament to indicate that the Trinidad and Tobago Police Service is ready to take certain aggressive steps, further steps in relation to gang activity. In that regard, there has been a very coordinated. The Commissioner of Police came to the government after the close of Parliament and said, the police have a special response team. It's called SORT, S-O-R-T. Sounds very similar to SORT, S-A-U-T-T. In other words then, they have the first limb of what worked in the anti-kidnapping structure. In asking for the return of bail restrictions, the Trinidad and Tobago Police asked for us to take as a matter of urgency the anti-gang and anti-crime drive mechanisms of bail restriction. Having passed this law in the Senate without opposition support but with independent support, we are now going to the Parliament tomorrow to introduce the bail amendments. And I would like to tell you that the amendments that we have with respect to the Bail Act are rather unique. They are slightly different from the previous bail laws, which had restrictions. In the previous bail laws, there was an automatic exclusion of the court. There was no circumstance, unless you had crossed no trial starting in 120 days, or the trial had not been completed after 1 year, the court could not consider the matter. In the amendments which we bring from the Senate, in the bill that goes to the House, we specifically say that you will have the right in exceptional circumstances to approach the court to ask for bail. That comes from the recent learning in Canada, where you effectively reverse the burden of proof. You tell the accused, you come and ask the court to consider why you should be given bail. That was not a feature of the previous 14 years of bail restrictions. But in this particular version of the law, we have come on what we call a charge basis. If you have a charge for any one of the scheduled offenses, the very bloody and very serious offenses set out in the second part to the schedule, if you have a charge for any one of those offenses and you are out on bail, and then you are charged again for one of those scheduled offenses, lightning will have struck you twice. You should be denied bail in those circumstances unless there are exceptional reasons that you can show to the court. So this is a very unique way of treating with the constitutionality of the bill. We say in a slightly different way that if you have a conviction for one of those scheduled offenses, and if you have a charge, well then we go back to the prior version of the law where there shall be no bail, 120 days, and the 1 year exception. So we have taken a very novel approach to the law, and we have done this in a very special, organized way, where the Trinidad and Tobago Police Service have asked us, now that they are ready with certain maneuvers and positions in gear, they have asked us to return to the Parliament. I would like to say to the country, listening as it is now, live as it is listening now, and in the edited, clipped version which the media houses will give later or will print later, I would like to say this law is critical to treat with the current battle against crime. The situation that we have seen is a very unique one. And I would like to point out that the only input that we have had from the opposition to any measure to reduce crime has been opposition. Their modus operandi, and you can go back and check the record for yourselves, has been to say no to almost every measure that comes up. They come with dilutions to the law which will not survive the application that it is required for. More particularly, they have no justification as to why what they suggest now should be different from what applied when they were in government. And it is important for the country to ask itself what it desires to be applied in this case. We genuinely believe that the bail amendments are required. If the Trinidad and Tobago Police Service have asked us for these amendments, then it is our obligation to put them into effect. I ask you to raise that genuine context, to pay attention to the differences in the law that we have brought out, to look at what existed prior and what is being pushed now, and to form your own view. May I open myself to your questions at this point?
Is Julian News from Newsday. Starting off with Cambridge Analytica. Just want to get it clear, is the hope or the intention to have Mr. Wiley appear before the GSC on Cambridge Analytica?
Yes, Mr. Wiley already provided his agreement to appear. Whilst we were engaged with his attorneys at law, it is to perfect that now, and it is also to use a separate opportunity to gather his evidence, Parliament to Parliament directly, keeping the privileges of Parliament in gear, and secondly, by way of mutual cooperation and assistance for law enforcement.
Do you have any idea of timeline for when he would appear with the session?
Well, the expectation is that upon the resumption of the Parliament, that we'll be able to confirm that, when the summonses and subpoenas can be issued accordingly. We have asked him to provide evidence and testimony. The usual rules around that sometimes involve witness conduct, as you call it. Mostly when people are summoned, you have to pay for them to arrive or have a daily transportation position. But nothing out of the ordinary or normal terms and conditions would be applied there. If you issue a summons right now in the High Court to subpoena someone, you have to pay them conduct money, etc. You have to remember, I should say this, Mr. Wiley's greatest concern in his discussions via his attorneys was for his safety. He expressly stated that he was fearful for his life. He expressly stated that he was deeply concerned that if he attended in Trinidad and Tobago on this issue, that he could very well be the subject of violence, if not worse. And he has asked the state, in the event that that is coordinated, to make sure that his safety is catered for.
So is it that he had greater concerns about his safety here than in the UK or in the United States?
Absolutely, yes. Those were his direct statements, that he fears for his life in coming to Trinidad and Tobago.
Explain why the fear was over and above the normal fears in this country.
Because in his work, according to what I am directly aware of, he saw a level of criminality and breach of the law in this country which was not equaled in other countries.
You also said that he wanted to waive certain publications, and I think you mentioned the documentary. So that, was it that he didn't want to say anything until that was dealt with?
You have to remember, whistleblowers walk a very careful line. If a whistleblower gives testimony without immunity or without privilege, immunity is where prosecutors say to you, well, we'll accept you and give your evidence as a whistleblower and we will not charge you. Privilege, if you give it in the parliament, you know that there's a privilege in section 55 of our constitution, similar to the UK, etc., where anything you say or do in the parliament is immune from suit by legislation or by certain other provisions if you don't have a written code, etc. So Mr. Wiley's testimony, if it is not given in certain careful circumstances, can open him up to liability himself. And it is because of that that the delay in the provision of testimony has been occasioned. You've got to be very careful, not only for physical safety, if that is what he apprehends, but also that you don't open yourself up to losing everything in life, including your liberty, by disclosing in less than careful circumstances.
My final question is on the jail bill. Has any effort been made to meet with the opposition before tomorrow to work out some sort of...
We've danced with the opposition on many an occasion. Not the best of experiences, because they say one thing and then do another. We've been to joint select committees with the opposition. I'll remind you of the Anti-Terrorism Act, where we had a unanimous joint select committee report. And then when we got to the floor of the parliament, they resiled from their own report. The parliament provides for a committee stage where all 41 members could speak on all the law and all the clauses in the full public glare, with the immortality of the Hansard record accompanying that. We prefer, if we have any discussions with the opposition, to do it in the full glare of the public.
They have said that there's a window of door open. Are you optimistic at this point that there will be passage of this bill tomorrow?
If common sense, reasonableness, and consistency of position on the law prevails, well, then I'll be optimistic. But I can't say that those are hallmark characteristics of the UNC from what I've seen from them. I want to remind you, in the Senate, the UNC tabled a number of amendments. Every last one of them were rejected, not only by the government, but by the independent bench. Let me underscore that. The independent bench also rejected their proposals because they would have resulted in a dilution of the law to make no sense in its application. I want to remind you that Trinidad and Tobago has a very unique constitution. Our section 13(2) of the constitution, where we uphold the 3/5 majority approach, that does not exist in other constitutions in the same way it is here. So we have a very unique situation. This is a matter of national security, and this is more than just proportionality in law.
I'm wondering if you can tell us just maybe the family of charges that can be applied to those found guilty in anything dealing with Cambridge Analytica.
Ooh. Let's start with the Interception of Communication Act. It's a criminal offense to intercept communication. According to the documentary and television interviews conducted in the United Kingdom, where Mr. Wiley featured, Mr. Wiley was speaking, as I recall, about intercepting what you were looking at online in Trinidad and Tobago, the videos you were looking at, what you were looking at. And that, if it is true, is an interception of communication breach. And that is resulting immediately in a jail term and fines upon conviction. So these are very serious matters. There are all sorts of positions. There may be breaches of licenses, agreements, there may be torts, or civil wrongs that are committed, which may also result in financial payout as well.
Ian Mason from TTT, the opposition have been saying that this bill is similar to like the anti-gang bill. The government is saying that this bill is critical, we need this. But having passed the anti-gang bill, there have been no visible progress coming up from that, and they're saying, well, this is just another anti-gang bill. So what is your answer to that?
Well, first of all, it's a fact that there have been charges under the anti-gang bill. Secondly, it's a fact that the evidence which stands behind the anti-gang investigations had to be reassembled only when the law was passed. I can tell you as a matter of direct knowledge that there are works in the pipeline right now. I can't speak too particularly about those things. I must speak very guardedly, which concern anti-gang work. But the power of anti-gang law is in its disruption. Let me explain this bail amendment thing in a very simple way. Trinidad and Tobago has to put a sense of nervousness, panic, and worry upon people who are criminals. One of the best ways to do that is to tell somebody who has a charge for a very serious matter that if you find yourself before the court for another very serious matter, you should be worried about your liberty. Isn't that fair? Isn't it fair that while we're talking about gang activity, for example, a number of persons who are interested as persons of interest in gang activity have existing charges? Isn't that reasonable to assume? Shouldn't law enforcement have a fighting chance to put those people away for a short while? But we haven't just shut the door on them. We've said, let's do as Canada does. Let's take the reversal of the burden of proof. You can still approach the court in exceptional circumstances and tell the court why you should be granted bail. When the UNC applied the anti-gang law, just after the declaration of a state of emergency happened, they boast about the reduction of crime because everybody was effectively locked up in their homes. They locked up thousands of people in the state of emergency, and they used the anti-crime, anti-gang law, anti-liberty provisions, the no bail provisions. They used it for a full 4 years whilst they were in office. What's the difference now? If it was good enough for Trinidad and Tobago when they formed government, what is the difference now, especially when this law is arguably more constitutional than the last law was? Can you spot a difference?
Peter Christopher from Trinidad Guardian. Going back to the Cambridge Analytica issue, I believe that earlier this year there was an in-camera GSC with regard to that topic of Cambridge Analytica. Was the Netflix documentary indeed eye-opening to the government in terms of the information provided, as opposed to what was, or if you could, what was discussed during that GSC?
Two things as a seasoned reporter. A, I'm not a member of the Joint Select Committee, and even if I was, the report is not yet complete, and therefore I'd be in breach of the parliamentary rules in discussing an ongoing JSC matter prior to the publication of its report. So I can not comment or answer any of those questions.
Yeah, and secondly, I find the claim that Mr. Wiley, well, I can't say I find that would not be a question, but the suggestion that he was unwilling because of his safety, how did you convince him that he would be safe in Trinidad given his concerns, and how did he come, would you be able to explain to a greater degree why he felt that he was unsafe to come to Trinidad?
I certainly couldn't put myself in the mind of someone else to explain their fear or lack of fear. I certainly couldn't do that. I'm not a mind reader. I can say that the man expressed it as a matter of fact. I can say that he's concerned about it as a matter of fact. I can say that when the world looks to the fact that Trinidad and Tobago has witnesses who are shot dead in our country, that can't be overlooked. This is high stakes. If what Mr. Wiley says is true, isn't it high stakes? If his evidence points to persons who were in political life in the last government, couldn't that in his mind be high stakes? Certainly I can't speak for a foreigner or the gentleman, but in his conversations via our attorneys as to his physical safety, it was raised, and we said that in the event that his testimony was to be given in Trinidad and Tobago, other than by video link or something else, that we would make arrangements which he would have to agree to ensure his passage from airport to testimony and in return. Okay? Then thank you very much for your questions and for your attendance this afternoon. I look forward to my 30 seconds on news time and to see how this has been edited. Have a good afternoon, everyone.